This sentence filing is going to split some people. Some will say excuses, others will say it's context. He keeps talking about a gun, but never says he was allowed to have one. And that's not an accident, because depending on how this is actually framed, this is either a dangerous criminal moment or a system stretching a story to justify prison. And that question matters more than the actual charge. Y'all ready for this? I know it's late, so hit that like button like you like something. Let's get into this continuation of the Boosie saga. We're going to ask this simplistic question of, and I want y'all to understand this, okay? It's going to get easier. The question is, why does that permit him to have a gun? That's the only question y'all should be asking. Because if they can't answer that, this whole entire argument is trash. So you can see his lawyer's name is Megan Blanco, and this is about the sentencing position. And it says, Defendant Torrance Hatch, by and through his counsel of record, Megan Blanco, files the attached sentencing memorandum for the reasons stated below. Mr. Hatch respectfully urges the court to sentence him to a 2-year probationary term with community service. Off the dribble, you should have just asked for 5, bro. I'm being all the way honest. You should have just asked for 5. The memorandum and Mr. Hatch's sentencing recommendations are based on the attached memorandum of points and authorities, the files in this case, and any other argument of information the court wishes to hear at the sentencing hearing. Respectfully submitted. Dated January 4th, 2026. Yeah, when we had got off the video yesterday, I was asking where this was, or if Boosie was going to throw himself at the mercy of the court. Looks like that's not going to happen, which honestly, he shouldn't have anyways. Like, hell no. You need your lawyer to fight something. Memorandum of points and authorities. Introduction. Mr. Hatch's life story is one of extraordinary adversity, resilience, and personal growth. He was born and raised in one of the most dangerous neighborhoods in Baton Rouge, Louisiana. If y'all know what Baton Rouge means, it means red stick. In case you don't party with funk sick. But anyways, an environment marked by violence, poverty, and instability. His father struggled with addiction and died when Mr. Hatch was just 14 years old. A traumatic loss that permanently altered the course of his childhood and left him without meaningful adult guidance at a formative age. Mind you, Boosie is 40 plus years old. Music became Mr. Hatch's primary means of survival and self-expression. From a young age, he uses to process grief, anger, and fear, and to articulate experiences shared by many young people growing up similarly marginalized communities. Over time, that outlet became his profession. Through discipline and persistence, Mr. Hatch built a successful career that allowed him to support his family, create legitimate employment for others, and ultimately leave behind the environment that shaped his early years. Importantly, Mr. Hatch's adult life reflects substantial maturation and law-abiding conduct. As the PSR confirms, there was an approximately 10-year gap between his prior criminal conduct and the instant offense. During that decade, Mr. Hatch focused on his career, his children, and community engagement. He did not reoffend, and he demonstrated that he was capable of living within the law, notwithstanding the difficult circumstances of his upbringing. Mr. Hatch has also used his success to give back to his communities. He has hosted annual food and holiday drives, supported families impacted by natural disasters, funded community events for underserved youth, and used his platform to speak directly to at-risk young people, avoiding the mistakes he made earlier in life. His charitable efforts are not episodic or performative. They are consistent, hands-on, and rooted in personal understanding of hardship. Mr. Hatch's life has also been marked by significant victimization, a factor that bears directly on his conduct and perspective. In November 2020, he was the victim of a shooting in Texas, an event that understandably heightened his sense of vulnerability and personal safety. That experience, combined with his public profile, has shaped his perception of risk while traveling, even as he now recognizes that his response in this case was misguided and unlawful. Following his arrest in this matter, Mr. Hatch was again victimized, this time through the criminal justice system itself. In United States versus Medina case number 24CR00248, Mr. Medina was convicted of attempting to extort Mr. Hatch by exploiting the publicity surrounding this case. Mr. Medina targeted Mr. Hatch along with other high-profile defendants charged with relatively minor offenses in an effort to extract money from them. Wait, what? Kind of crazy how he risked his freedom just to go to California and hang around a bunch of neighborhood Crips and have a gun. But what you know is not crazy? Boom, our sponsor. That's correct. Look, man, free cash. Hit the description in the link or tap the doggone QR code and win some cash today. Nobody, and I'm telling y'all, nobody has said this is a damn scam. What only complaints is the amount of money that they actually got. $60, $40, $20. Somebody even bragged $80 yesterday. So scan the QR code, listen to me in the background, or tap that description in the link, and let's continue on. This following is the defense asking the judge not to send him to prison and instead give him probation, community service. It paints him a picture of a kid who grew up around violence, lost guidance early, turned to music to survive, and later built a career, family, and money the legal way. It keeps saying this wasn't a pattern, but a single bad decision. It keeps reminding the court that he showed up to court, followed the rules, and didn't reoffend. And the quiet message underneath, all of this is simple but controversial. This case should be about who he became, not who he used to be. I know. Brings the tear to your eyes. Let's see if this shit works. Roll it. Despite these challenges, Mr. Hatch has responded appropriately since his arrest. He has complied fully with pretrial supervision, respected the authority of the court, and accepted responsibility by pleading guilty. He has expressed genuine remorse, particularly with respect to the impact of this case on his children, whom he has worked hard to protect from the instability that defined his own upbringing. In short, Mr. Hatch is not defined by the instant offense. He is a man who rose from extraordinary adversity, contributed meaningful to his community, and has taken responsibility for a serious but isolated lapse in judgment. These history and characteristics strongly support a sentence that is individualized, proportional, and oriented toward continued rehabilitation rather than unnecessary incarceration. B. Procedural history. Mr. Hatch was initially charged in state court arising out of the conduct at issue in this case. He was released on bond and appeared at every scheduled court proceeding, complied with all conditions of release, and conducted himself appropriately throughout the pendency of the state case. After thoroughly reviewing the facts of this case, Mr. Hatch's personal history and characteristics, the presiding state court judge indicated a willingness to resolve the matter with a probationary disposition, reflecting the court's assessment of both the limited nature and the offense conduct and Mr. Hatch's stability for supervision in the community. That's what you want. You want to absolutely bring up the fact of what the judge said previously on X-Men, but previously in the case before. When Mr. Hatch and his counsel appeared in state court prepared to accept that disposition, the district attorney dismissed the state charges. Immediately thereafter, federal agents arrested Mr. Hatch in the hallway of the courthouse and transferred him into federal custody. Mr. Hatch was subsequently brought before this court, where the then assigned United States attorney moved from detention. Mr. Hatch was initially placed on home confinement. The home confinement condition has since been removed, and Mr. Hatch has remained fully compliant with all court orders and has proceeded through the federal case without incident. And this part matters because it shows how close the case was already to being over. He was first charged, state court, bonded out, showed up on time every time, followed every rule, and the state judge was ready to resolve it with probation. Then something unusual happened. The state charges were dropped, and federal agents arrested him in the courthouse hallway. Since then, he stayed compliant, avoided trouble, and even had home confinement lifted. The defense is quietly saying this proves he's not a danger. But the question nobody answers is why the feds stepped in after the state was ready to let him walk. Now, some could argue, well, a state is a little bit easier. The state typically does this shit. The guidelines are harsher for the feds. And I'm probably going to lean with the second one. Where the hell are you leaning on this one? Because we all know people pray that their charges stay state and pray that the feds don't pick it up just because of the harsher penalties. Or maybe it's something different. Y'all, let me know real quick. On May 6, 2023, Mr. Hatch was in San Diego for a brief work-related visit connected to a paid music video shoot and upcoming performance. He traveled with a small entourage that included a hired driver and a security guard. There was no allegation that Mr. Hatch traveled to California to engage in criminal activity, traffic firearms, or commit acts of violence, though he brought damn guns all the way to the state with his girlfriend's name on it. But it's all about protection because he was shot prior but it's still illegal in interstate commerce. Like when you're doing that, when you're transferring guns, the feds are going to pick that shit up almost all the time. Earlier that day, law enforcement became aware of of a short social media video clip associated with the music video shoot. During a portion of that recording, Mr. Hatch was momentarily seen with a firearm placed in his waistband as part of the visual staging of the shoot. No firearm was discharged, brandished toward any person, or used to threaten anyone. That's a pretty good argument. So basically saying, yeah, he was hiding in the crack of his ass. Later that afternoon, officers conducted a traffic stop of the vehicle in which Mr. Hatch was a rear seat passenger. The stop was not initiated in response to any report of violence or harm. Mr. Hatch complied with law enforcement and did not attempt to flee or resist. No individual was injured and no victim was identified. During the stop, officers recovered 2 firearms, one located in a satchel worn by the security guard and another on the rear seat of the vehicle. The firearms were lawfully purchased outside of California and had been transported to San Diego by the security guard who registered them with the TSA. The government has not alleged that the firearms were used in connection with any other offense, nor that Mr. Hatch intended to use them for unlawful purposes. The incident occurred during a short visit in a controlled setting and was limited in scope and duration. The case represents an isolated lapse in judgment, not a pattern of ongoing criminal conduct. The government places significant weight on alleged statements purportedly made by Mr. Hatch at the precinct, characterizing them as evidence of dangerousness and violent propensity. The characterization is not supported by the contemporaneous record. Oh. Well, law enforcement actually documented at the time, and what officers did in response to Mr. Hatch's medical condition materially undermines the government's reliance on these allegations. So they flat out just said, y'all lied. This might get messy on Friday. Yeah, I'm just gonna be honest with it. A contemporaneous police reports. Why the hell, bro? It's typos in this shit. I know, man. Look, I'm out my mind. I'm kind of slow, but I know good and damn well contemporaneous police reports do not document threats. They don't. Oh, okay. The initial police reports do not document threats of any kind. Rather, the contemporaneous narrative reflects a verbal exchange between Mr. Hatch and Mr. Johnson concerning the location of the firearm. Specifically, the report states that Mr. Hatch asked Mr. Johnson why he told officers the gun was on the seat. Mr. Johnson replied that he told detectives the firearms was his, and Mr. Hatch responded, "You told me they were in the bag." Oh. So y'all lied on Boosie. Wow. The exchange constitutes the entirety of the documented interaction. There is no reference in the initial reports to threats, promises of violence, bounties, or any intent to harm anyone, including Mr. Johnson. The absence of such allegations in first instance documentation is significant. Had the extreme threats later attributed to Mr. Hatch occurred, they would reasonably be expected to appear in contemporaneous police reports. They do not. That is very true. Oh, this lawyer is cooking. I like this damn lawyer. No audio or video evidence corroborates the alleged statements. The absence is particularly notable because Mr. Hatch was being recorded during portions of his detention. Yet, none of the alleged threats appear on any audio or video recorder, despite functioning recording equipment and extensive documentation of other statements and conduct. So y'all cats was lying on Boosie the whole entire time, calling him a damn snitch when none of that shit actually happened. The government thus asked the court to credit alleged statements that are unrecorded, absent from contemporaneous reports, and inconsistent with the documented narrative. Under these circumstances, the statements lack sufficient indication of reliability to support aggravation at sentencing. Officers declined to provide medical care and instead collected evidence. At the time of the traffic stop and subsequent detention, Mr. Hatch, who has type 1 diabetes, was experiencing dangerously low blood sugar. He requested food and medical assistance, and his entourage was actively traveling to obtain food because his physical condition was deteriorating. This section is where the defense starts poking holes in the story the government once told. It says the traffic stop didn't start because of violence. Nobody was threatened, no shots were fired, and no one was hurt. The guns weren't waved around or used. They were found during a search, legally brought by someone else, and never discharged. And when police later claimed he made threatening statements, the defense points out something uncomfortable. None of those threats show up in the original police report, audio or video. The defense is basically saying the dangerous version of this case was written after the fact, not in real time. And this is where I always make sure to listen to stories when these rappers try to tell me certain things, because there are a couple of cases that I sat back on and didn't report on because of what was in the report and what actually makes sense. See, a lot of people don't know this, but police officers can go back and write certain shit and fix their report, and there's no penalty. But what's not there, and I need everybody to understand, they factually said majority of Boosie's time that was spent there, bruh, it was already recorded. So while that cop is running around with that damn body cam, where that footage at, where that audio at, they don't want to say it, but I'll say it. They're saying the feds made that shit up. Or the police did. And the feds just don't give a damn. But I told y'all, the feds play dirty. Law enforcement was aware of Mr. Hatch's diabetic condition and his worsening symptoms. An officer called in a code 1141. Ambulance needed after Mr. Hatch stated he was a diabetic and deteriorating. And then you can see on May 6, 2023 at 3:44 with 12 seconds, 7902 OPS 1141 for male saying he is diabetic. What the hell is this? The hell? Hypoglycemia is known to cause confusion, agitation, impaired judgment, and emotional dysregulation, particularly when untreated while in custody. Mr. Hatch repeatedly requested that his blood sugar be checked. Officers performed a finger prick blood test. However, rather than provide treatment, food, or medication, they impounded the blood sample and submitted it for DNA testing. Nigga, what? Mr. Hatch was not provided medical care. The police reports reflect that officers elected to retain the blood sample for evidentiary purposes rather than address his medical needs. This sequence matters. It establishes that officers recognized Mr. Hatch was experiencing a medical issue, treated it as such in real time, and did not contemporaneously characterize his behavior as threatening or criminal in nature. The court should decline to recast a medical event as aggravation. Sentencing must rest on reliable contemporaneous information. But I'm about tired of saying this goddamn word. The record reflects that Mr. Hatch was medically compromised, seeking food and medical assistance, and involved in a verbal disagreement regarding evidence, not making criminal threats. Unfortunately, Mr. Hatch's ability to recall the events with precision was compromised due to a serious and untreated medical condition following his arrest. And that's crazy because the damn feds in the previous video, let me know if y'all want me to. I'll link it in the comments. They shitted on his medical condition, said he wasn't taking care of himself. To treat this episode as aggravating would effectively transform a documented medical event into evidence of dangerousness. That result would be inconsistent with due process and the sentencing principles set forth in 18 U.S.C. 355A. The 355A factors support a sentence of 2 years probation with community service. A sentence of 2 years probation coupled with meaningful community service requirement is sufficient but not greater than necessary to satisfy the purposes of sentencing under 18 U.S.C. 3553A. Such a sentence appropriately balances accountability, deterrence, rehabilitation, and proportionality while recognizing the substantial punishment Mr. Hatch has already endured. And this is the part where the defense slows down everything and rewinds the moment. It says he came to San Diego for work, not crime, not to stop and do no bullshit, no violence. Nobody was hurt, nobody ran, no shots were fired, and no one reported a victim. The guns were found during the search, stored away and never used. And when the government later claimed he made scary statements, the defense points out something that hits hard. Those threats didn't show up in the police reports. Body cam, audio, the defense is saying this looks less like a violent incident in real time and more like a story that got heavier after arrest. And we gonna be honest, they're making it seem like because it's Boosie, there might even be a personal vendetta against him. Just gonna be honest. They're literally, Boosie said in the filing, hey, bro, his previous shit that he said, once they found out it was me, they turned it all the way up. So now it goes to celebrity targeting. And he a gangster rapper, so it kind of makes sense, right? Nature and circumstances of the offenses. The offense conduct was limited, nonviolent, and isolated. Mr. Hatch did not discharge a firearm or cause harm. No victim was identified, and the government has not alleged that the firearms were used in any connection with any other criminal activity or broader criminal scheme. The conduct occurred during a brief work-related visit to San Diego and reflects a lapse in judgment rather than ongoing criminal behavior. Section 3553A requires the court to sentence based on the actual circumstances of the offense, not on hypothetical risks or overstated characterizations unsupported by the contemporaneous record. Bruh, come on, stop saying this word. That's it, pop up on the bottom already. To the extent the court considers alleged statements attributed to Mr. Hatch at the precinct, those allegations should be weighed cautiously. They are unsupported by audio or video evidence, absent from contemporaneous police reports, and arose during a documented medical emergency involving untreated hypoglycemia. No charges were brought based on threats, and no protective action was deemed necessary at the time. Because if I got somebody threatening another inmate, you're supposed to separate their asses. Y'all kept them there, which was always a little shaky any damn ways. Sentences should rest on reliable conduct, not disputed characterizations of a medical episode. History and characteristics of defendant 355A1. Mr. Hatch's personal history strongly supports a probationary sentence. As reflected in the PSR, there was an approximately 10-year gap between his prior criminal conduct and the instant offense. During that period, he lived law-abiding, raised his children, maintained employment, and engaged in sustained community support. Since his arrest, Mr. Hatch has demonstrated that he is amenable to supervision. He complied with all court-ordered conditions, including nearly a full year of home confinement without incident. He appeared as directed, followed supervision requirements, and accepted responsibility by pleading guilty. Then, this section flips the story again. The defense says this wasn't a dangerous outburst. It was a medical emergency. Police knew he was diabetic, knew his condition was getting worse, and even called for an ambulance. He kept asking for his blood sugar to be checked. They tested it, but instead of giving him food or treatment like orange juice or some chocolate or something, they took the blood sample and logged it as evidence. No medical care. The defense is saying confusion, agitation, and bad judgment came from low blood sugar, not criminal intent. And here's the sharp line. If officers treated it like a medical issue in real time, the court shouldn't later rewrite it as violent just to make the sentencing worse. Because if I'm having an episode, and I don't know, y'all know, I've witnessed, I had a grandma who was diabetic, God rest her soul, and when her sugar would be low, she would be dry. It would seem like she was drunk. Like Jackie Chan in what the hell is that movie? Drunken Master or whatever the hell, and he was fighting like this, but she wasn't squabbling though. She probably would have stabbed you, but still, that's Mississippi for you. But yeah, bro, it's one, you can make an argument, and they pretty much do. So, to be fair, it's kind of wild that this didn't go to trial because I don't think it would go in Boosie's favor. But right now, it looks a little good. His conduct throughout this case confirms that the instant offense is an aberration, not a trajectory. Sentence must reflect real punishment already imposed. Mr. Hatch has already experienced significant punishment. He was subject to nearly 1 year of home confinement, a substantial deprivation of liberty that meaningfully restricted his movements, employment, flexibility, and family life. Home confinement imposed continuous monitoring, limited travel and professional activity, and a significantly constrained daily life. Courts routinely recognize such conditions as serious punishment, not a nominal sanction. Okay. Under 3553A, that already served punishment must be weighed in determining whether additional incarceration will be greater than necessary to reflect the seriousness of the offense, promote respect for the law, and provide just punishment imposing custody on top of that sanction would risk access rather than proportionality. Deterrence and protection of the public. 3553A2BC. The goals of deterrence and public safety are fully satisfied without incarceration. Specific deterrence is demonstrated by Mr. Hatch's post-arrest conduct. He has complied with supervision, avoided new violations, and taken concrete steps to ensure this conduct doesn't occur or does not occur. General deterrence is achieved through the public nature of this case. The federal prosecution itself, prolonged supervision, and nearly a year of home confinement, additional incarceration would provide little incremental deterrence value. While Mr. Hatch has previously served lengthy custodial sentences, the record reflects that those sentences were followed by a substantial period of lawful conduct, family stability, and professional success. Deterrence is not measured by perfection, but by whether a defendant meaningfully altered his life trajectory, which Mr. Hatch did for many years. The instant offense represents a lapse in judgment, not a rejection of deterrence or a return of entrenched criminal conduct. Nothing in the record suggests that Mr. Hatch poses a risk to the public, and his conduct since arrest demonstrates stability, compliance, and accountability. Rehabilitation is best served through structured supervision and community service. Probation allows the court to impose structure, accountability, and continued oversight while permitting Mr. Hatch to remain a productive member of the community and a stable presence for his children. Concerns that Mr. Hatch's profession exposes him to risks can be addressed through structured supervision rather than incarceration. Since his arrest, Mr. Hatch has complied with firearm prohibitions and demonstrated that he can conduct his work within the bounds of supervision. Probation, combined with explicit conditions and community service, directly mitigates the risks identified in the PSR. As a condition of probation, Mr. Hatch respectfully proposes a substantial community service requirement focused on underserved communities and youth outreach. He has demonstrated history of hands-on community involvement, including food services, food drives, disaster relief support, and youth engagement, formalizing that work through court-ordered community service converts punishment into tangible public benefit. But they're going to argue, and I would too, he been doing this shit, and it didn't deter his ass from breaking the law anyways. I mean, all this sounds good and kumbaya and let's sit in front of the bonfire. But if we're going to be all the way honest, bruh, you've been doing this shit. So how is it punishment if you've been doing it? Like, hey, I hope he gets probation. But to me, if I'm arguing, I'm saying, Judge, he been doing this shit. So I know some of y'all like, hell nah. Sorry, bruh, my throat just got dry, so I don't even remember where I was at. Work through court-ordered community service converts punishment into tangible public benefit. Community service is particularly appropriate here because it reinforces accountability, promotes rehabilitation rather than disruption, directly benefits the community, and aligns with Mr. Hatch's demonstrated capacity to contribute constructively. Continued supervision in the community also ensures access to appropriate medical care for Mr. Hatch's type 1 diabetes, an important consideration given the medical complications documented in this case. That's where y'all really should have harped on, in my opinion. Y'all should have kicked ass with that. Avoiding unwarranted sentencing disparity. A probationary sentence with community service avoids unwarranted sentencing disparities. Golly. Avoids unwarranted sentencing disparities. The state court that initially reviewed this matter indicated a willingness to resolve the case with probation, reflecting a reasoned assessment of both the offense conduct and Mr. Hatch's suitability for supervision. While this court exercises independent judgment, that assessment underscores that probation is a proportionate outcome for this conduct. As a condition of probation, Mr. Hatch is prepared to complete no fewer than 300 hours of community service focused on underserved communities, youth mentorship, and food insecurity. Formalizing this obligation ensures accountability by advancing the rehabilitative goals of 3553A. Conclusion. For the foregoing reasons, Mr. Hatch respectfully urges the court to sentence him to a 2-year probationary term with community service. Respectfully submitted, dated January 4, 2026. Nigan Blanco, counsel for defendant Hatch. This is where the defense goes all in. They're telling the judge this wasn't a pattern, this wasn't escalation, and this wasn't some dangerous lifestyle spinning out of control. They walked through the entire life, growing up broke, surrounded by violence, getting shot, losing guidance early, and still building a career, supporting his family, and giving back to the community. One mistake, one short incident, no victims, no threats, no shots fired, all over again. And prosecutors want to turn that moment into who he is forever. It's like the old saying, don't judge a person off of one bad mistake they made. The defense is saying the punishment already happened and prison would be excessive, not justice. And this is where people split. Some will say the rules are rules and consequences matter, no exceptions, right? Others will say locking someone up here isn't justice, it's overkill. So where do you land? Probation or prison? Rehabilitation or punishment? Drop your damn comments or your side in the comments. Don't sit on the fence on this one. If this breakdown made you think like me a little bit, hit that like button, man. Subscribe and stay locked in, because this sentencing decision is going to tell us a lot about how the system really, really works. Because at one point in time, having a gun didn't really matter. It was a misdemeanor. So remember that. It used to be a misdemeanor and not a felony for having a firearm. IRA. The NRA failed us. But it always does, especially when it comes to California and this color right here. Y'all got to remember, Ronald Reagan is the reason why we don't have open carry. Well, we didn't have open carry and such gun restrictive laws in California. Republican. But they claim First Amendment, right? No, 2A. Bullshit. But hey, y'all know what to do, man. Hit that like button like you like something. And let me know y'all thoughts on this one. I know it's late, so it is what it is. But click right here to see how Dirk's federal nightmare continues. And boy, this shit ain't good. We find out what I already knew, but I didn't know this shit was that long. Find out what I knew but didn't know about, and what you should definitely know, especially if you got loved ones in the feds. Click right here, or click right here for the playlist, and I'll catch you on the next one.